One of the issues that comes up for the employers we represent is whether they have to accommodate the work restrictions of a pregnant employee. Terry Bonnette of our office is here to talk about that. And it's my understanding the Equal Employment Opportunity Commission has guidelines that require the employers to do some things. Can you talk about that?
Yes, last summer the EEOC issued guidelines that essentially say that if an employee is temporarily unable to perform some job functions because of pregnancy, they have to be treated the same way that any other employee who is temporarily unable to perform job functions is treated.
And it's also my understanding that the United States Supreme Court is undertaking a case, United Parcel Service, that's going to address some of these issues.
Well, the issue that's being addressed by the Supreme Court is whether or not an employer who offers light duty to employees who are injured on the job is also required to offer light duty to an employee who is unable to do their job because of pregnancy.
So what happens if the United States Supreme Court says to employers, and this is going to be on a nationwide basis, employers, UPS, you have to provide light duty to your pregnant employees?
Well, first of all, on a side note, I think it's important to note that UPS has actually changed its policy since this case began to do just that.
Okay, that's interesting.
Yes. And if the Supreme Court says that all employers are required to do this, employers are going to be forced to look at their workers' compensation programs, and if they're offering light duty under those programs, to decide whether they want to open them up to pregnant employees as well and provide light duty to anyone who needs it, or if they want to simply eliminate those workers' compensation light duty programs so that they don't have to offer them to anyone.
So it looks like there's going to be some analysis going on if that happens. But what happens if the U.S. Supreme Court says to UPS that you do not have to offer light duty to your pregnant employees?
Well, certainly, as far as light duty is concerned, the Supreme Court decision would trump the EEOC guidelines. However, those guidelines go far beyond just light duty, and the other portions of those guidelines would remain in effect.
Under Michigan law, employers are required to treat pregnant employees the same as they would employees who have been injured on the job. Is that your understanding as well, Terry?
Yes. Under Michigan law, a couple years ago, the Michigan legislature amended Michigan's pregnancy discrimination laws to require employers to offer, accommodation without looking at the cause of why it was needed. So if you offer it for workers' comp, under Michigan law, you would also have to offer it for pregnancy.
Okay, so the United States Supreme Court decision, UPS, is going to be decided sometime in 2015. We're waiting on that. But in the meantime, employers, if they have any questions as to whether or not they need to provide light duty work to individuals who have worker comp injuries or to pregnant employees, they should pick up the phone and they should call Terry.